Counsel.
Good morning, Your Honors. I'm Barbara Basharis, representing William Wells. I've asked for 5 minutes for rebuttal. Thank you, Your Honors. This morning, Mr. Wells is asking this court for a new penalty phase hearing in his capital trial, where he was sentenced to death for the killing of a fellow inmate in the Department of Corrections. I'm going to concentrate on the first issue that was raised in the brief, which is the trial court's abuse of discretion in failing to give trial counsel a continuance to adequately prepare a mitigation case when Mr. Wells elected to have representation during his penalty phase. The right to counsel includes the right to a reasonable time for counsel to prepare. And in capital cases, that time is extremely important because of the heightened duties that capital counsel have to investigate all aspects of the case, including potential mitigation. There is no exception to capital counsel's duties merely because somebody has been tried before and has previously existing transcripts or mitigation. Capital counsel have an independent duty to investigate all aspects of a case, including mitigation, and to present
How long
them.
did he have? How long did counsel have?
Counsel was appointed.
That's a pretty direct and simple question. How many months?
It is, Your Honor. I'm trying to count in my head.
So you don't know how long?
I do know.
You're arguing he didn't have enough time, but you don't know how much time he had?
I have the chronology right here, Your Honor. Counsel was appointed as standby counsel when the penalty phase began. Mr. Wells asked for counsel at the close of the state's case in August 2020, I believe, and the penalty phase the mitigation part of the penalty phase happened in April 2021. So from August to April was the time delay, which is August, September, October, November, about 8 months. During that time, the court system and lawyers in the system were hampered by the COVID-19 pandemic. That was repeatedly referred to during status conferences on this matter, and it was referred to in counsel's request for additional time to prepare. The pandemic prevented the interviewing of witnesses. It prevented travel. As Your Honors know, it inhibited all aspects of practicing law, particularly
let me
in
ask you this. In this case, didn't your client request to represent himself and fire appointed counsel?
Initially,
initially, and then the counsel was taken off the case. A standby counsel was put on, and then later on he requested counsel again.
correct.
Got counsel again, and then fired him again. And the question I have for you is this, and obviously this it didn't happen in this case. Well, what if you have someone who is pretty savvy with the judicial system and we get appointed counsel, fires him, we'll go a couple of years, then he's back in court, I want counsel, a couple of years go by, fire that counsel, and a couple of years go by, I want another counsel. I mean, you can play the system doing that kind of thing, and I guess if you're sitting on death row, you want to postpone things as long as possible.
Some people do.
But yeah, I'm not saying it happened in this case, but it kind of started that way. So what I'm asking you is, because I'm a big believer in people having counsel, and I think it's in these type of cases where death is involved, I think people should have counsel all the way to the end if it comes to that. I'm a big believer in that, but by the same token, I don't like the system being played either. So what do we do in a situation like that where counsel fire, and you play that game? What are we supposed to do with that?
I think at that point, Your Honor, you do what courts are called on to do in a variety of situations, which is a fact-specific, case-specific look at whether the system is being played, whether there is an indicator of delay or a strategy of delay. And that's something trial courts have to do all the time when they're ruling on continuances. It's one of the factors that a trial court...
Are you asking us today to adopt a new rule with respect to what the trial court's discretion is with continuances generally? Because it would seem to me that application of the normal abuse of discretion standard here yields a pretty clear and easy result. Help me understand why application of the abuse of discretion standard here, absent some modification of it, counsels an outcome in favor of your client, because I don't see it.
Okay. Your Honor, the abuse of discretion standard depends on reasonableness, and I'm not asking for any different standard to be applied. Mr. Wells' position is that it is unreasonable in the context of a pandemic that had affected the court system, affected counsel's preparation to...
You're saying no reasonable judge could have denied his request. It of necessity would have required every single trial court judge in Florida to have granted the request your client made, notwithstanding you've conceded 8 months of preparation time. I believe we'll hear from the state about, I would expect in the briefing that I saw from the state that actually the story is a little bit more complicated than just 1 8-month shot. Leaving that aside, it can't really be your argument that no trial judge in Florida could have considered this and reasonably denied it. Is that really what you're arguing?
That is the abuse of discretion standard, Your Honor. And again, it is specific to this case. It's specific in 2 ways. One, that it is a capital case, and this case was already on a fast track when it went into the penalty phase. The arraignment had been in November 2019, and the penalty phase began in March of 2020. That's extremely short time, and part of that was because Mr. Wells initially waived counsel, as Justice Labarga pointed out, had a slight change of heart about that, but his slight change of heart did not delay the proceedings, and it didn't delay the penalty phase from beginning in March. So this case was on a fast track when Mr. Wells exercised his right to ask for counsel, to be reappointed. And at that point, he had the right to competent counsel. And counsel was very clear, even before the reappointment, that if counsel was asked to jump in again because of the complexity of the case and counsel's ethical responsibilities, they wouldn't be able to keep it on the same fast track. And the trial court said that it understood that. And as soon as counsel was reappointed, counsel asked for more time in a detailed motion, talking about the number of witnesses that were potentially available or necessary to talk to, and the complexity of the case. And counsel continued to reiterate those concerns right up until the mitigation phase of the trial began, and continued to inform the court that COVID and the pandemic had affected counsel's ability to fully prepare the mitigation case. Also continued to inform the court that counsel could not discharge his ethical responsibilities simply by relying on mitigation that someone else had prepared for a prior proceeding. So yes, in that context, I am saying it was unreasonable not to give this counsel additional time to prepare the mitigation case.
But it's so unclear. Counsel had a year to prepare in this case, from appointment date to trial date.
From the appointment date to the trial, yes.
Yeah, about a year. And of course, Mr. Wells went through a mitigation procedure in the past, and all the records were there.
And again, having the records from a prior case does not excuse counsel's responsibility to do additional investigation.
I know, but you don't start from bottom up. I mean, you have something to read and grow from there.
Yes.
I would think that would not take as long to prepare. It helps in the preparation, that is.
It might not take as long, but your honors know how long some of these cases take to prepare. I mean, there are capital cases that take 3-4 years or more to prepare, to fully prepare. And so to say that a year was long enough, especially in the face of the specific representations that counsel made to the trial court, that's what's unreasonable here. Every case is different. And of course, the court was not starting from a completely zero point in this case. But that doesn't mean that counsel could discharge his responsibilities ethically without having additional time. I also
do you have anything specific that counsel wasn't able to do? I mean, it looks like to me that actually it was a pretty good job in trying to present mitigation here.
Well, and I think, Your Honor, that to answer your question directly first, I think the witnesses that counsel did not have time to talk to are the specifics that trial counsel identified, both in written and oral motions. But
which witnesses did he ultimately not get to that were excluded from the mitigating evidence presented?
Those specific witnesses were not identified. What he did identify were that over 90 state witnesses had been listed, and that he simply hadn't had time to pursue deposing or interviewing those. So, Capitol Counsel is supposed to have face-to-face interviews in capital cases with potential witnesses. It's not enough just to call someone on the phone. The development of a mitigation case is extraordinarily detailed and with a lot of attention to individuals. That's one of the reasons these cases have mitigation specialists who can assist trial counsel in developing that. So it was the potential
state witnesses? It was the potential state witnesses. Is that what you said?
These were potential witnesses listed by the state.
But the state had already rested. The state's case was done before this preparation even started, was it not? Because the penalty phase had already started before he had counsel reappointed.
Correct.
And so there was a continuance granted for the defense to prepare the mitigation, but the state had already called all the witnesses they were going to call. There were not 97.
That's correct, Your Honor. But there's still potential mitigation that could be developed from speaking to witnesses on that list, as counsel repeatedly said. And I want to note that, as Justice Kennedy just alluded to, counsel was not sitting around doing nothing. Counsel did prepare a mitigation case. Counsel presented extensive expert testimony about Mr. Wells's mental health, his mental health history, the effect of incarceration and the management of the Florida prison system on the events leading up to the charged offense. So counsel was not doing nothing, but counsel still repeatedly told the trial court that they needed more time to prepare for mitigation. And in the context of the pandemic and of how fast this case was moving already, it was not reasonable to deny counsel some additional time to prepare mitigation. I want to note that when the case began, I believe was the same week that the pandemic caused the shutdown. I believe that was the same week that this court began issuing administrative orders in response to the pandemic, and those administrative orders continued past the conclusion of this case. So during the entire pendency of this case, the court system was operating under special rules. During the entire pendency of this case, speedy trial was suspended to give the state additional time to bring its cases because of the effect of the pandemic on the administration of justice. So if the court system had to recognize the effect of the pandemic to that extent, surely it was not reasonable to...
I have a question. During the, am I right that during the pendency of the case and the pandemic orders that you're recounting, the court did grant several continuances. Am I right? How many continuances did your client seek?
There was a continuance asked for when Mr. Wells requested counsel near the end of the state's evidence, and that continuance was granted.
Were there any others?
There was not a continuance. There was a stay.
Yes.
While Mr. Wells sought review in the First District Court of Appeal, and I believe that lasted until February of 2021.
Okay.
It lasted for approximately 3 months.
Okay.
As far as I can tell from the chronology that I see, that stay did not significantly delay the process of the case towards the conclusion of the penalty phase or the presentation of the mitigation. But you're correct that there was that short period of time as well. So, if you have no further questions, Your Honors, I will reserve the remainder of my time. Thank you.
May it please the Court. Steve Woods on behalf of the state. I suppose I'd begin with probably the most favorable point for the state, a very obvious one. This is an abuse of discretion standard. So, as has already been stated, in order for them to win, they would have to show no reasonable trial judge could have ruled the way this judge ruled. So the case law says it must be a palpable abuse of discretion. And the issue properly framed is not whether they denied a continuance. This was an additional continuance. So from the time that the lawyer was reappointed to the resumption of the penalty phase, there are 265 days, which is roughly 8 or 9 months. It's only the penalty phase they have to prepare for. This, of course, was a guilty plea. He represented himself. He insisted on pleading guilty. He waived the jury at the penalty phase. As we've gone over, the state had already presented all of its witnesses. What's been said about the 2017 transcript? This transcript had several of the same witnesses who testified in April of 2021 at the penalty phase in this case. I suppose another point I'd make with respect to abuse of discretion, this delay was caused by the defendant, and he complains of the very problem that he caused. He chose to proceed pro se. He pleaded guilty. This moved things along. He said, I have no mitigation. I intend to present no defense. I don't want the penalty phase jury. I want the death penalty. And this is what was going on until August 4th, which was the second day of the penalty phase. And at that point he says, well, okay, now I want the standby counsel. And the judge says, okay, under these circumstances, I consider it appropriate to grant a continuance. And the judge did that, the state objected, and then it is 265 days until it resumes. Another point the state would emphasize is that these requests, we would respectfully maintain that they're nonspecific and they're vague. There's nothing definite. It is nebulous stuff. What they say is, well, this is the coronavirus. There were a lot of pages we had to go through from DOC. It was not chronologically ordered. 75 witnesses, but these are guilt phase witnesses, and of course there was no guilt phase because he pleaded guilty. And they say, well, we don't know. We have to go through all this stuff in an attempt to find mitigation. Maybe we could, but the mere possibility doesn't justify a continuance. Much of what they say they had to do could have been done over the phone. The coronavirus, of course, was the coronavirus. In the record, there are many cases in which the judge says, well, what exactly is your plan? I need a good faith statement from you as an officer of the court saying, you plan to do this, you need this much time, these are the persons to whom you need to speak. And there's really nothing given with respect to definitely what had to go on. So, of course, the case law requires a palpable abuse of discretion, which is just not here. And there's no clear and affirmative abuse of discretion. So Your Honors, if there are no questions, the state very respectfully asks that this honorable court affirm. Thank you.
Thank you, Your Honors. Yes, Mr. Wells changed his mind. Mr. Wells stated initially that he wanted the death penalty, and then he decided to fight instead. And that is his right. It's his human right, and it's his legal right to do that. And he shouldn't be penalized for exercising that any more than he would be penalized for having made the decision in the reverse, to fight first and then to decide to waive.
How do you think
rights.
the court's rulings penalized him for exercising that right?
By once he asked for counsel, denying counsel adequate time to prepare. And in response to what the state pointed out about the lack of specificity, I can only say we don't know what we don't know. We know that there was a quantity of witnesses that the counsel did not have time to speak to. We know that there were extensive documents. Even as late as the actual pronouncement of sentence, counsel was referring to video that counsel hadn't had time to fully review. And so at every step of the penalty phase, once standby counsel became counsel again, counsel was telling the court, we need more time to adequately prepare, we need more time to discharge our ethical responsibilities, and they weren't given that time. So that's how Mr. Wells was penalized. So yes, he did put this case on a fast track in the beginning, but once he made that decision to try to fight for his life and challenge the sentence of death, then he should have been given every opportunity through counsel for counsel to do counsel's job and represent him. Because the right to counsel is the right to competent counsel. It's not the right to somebody who will fast track the case as quickly as Mr. Wells might have done in the beginning. It's the right to counsel that's going to do a thorough and ethical job. And that's what counsel was prevented from doing here, especially, again, in the context of the pandemic. So we ask, Your Honors, for a new penalty phase hearing for Mr. Wells. Thank you very much.
Thank you, counsel. And with that, we are adjourned. Thank you.
All rise.